Hi there. Are you a tenant with a case in Landlord-Tenant Court? My name is Jordan, and I'm an attorney on the housing team at Neighborhood Legal Services Program, where I help my clients whose landlords have sued to evict them. In today's video, I'm going to give you some information on initial hearings and further initial hearings. This information is meant to help tenants who are representing themselves in court without a lawyer, which is called being a pro se tenant. If you would like to see if you qualify for free legal assistance, you can call the Landlord-Tenant Legal Assistance Network at 202-780-2575. The information in this video is not legal advice, and it's specific to courts in Washington, D.C. because the laws do vary across the country. I'm recording this on March 27th, 2025. Let's get started. Feel free to pause this video at any time if you need to check out the text on the screen. Today we'll review 4 main topics. Number 1, how to access your court docket. Number 2, what to expect at your initial hearing. Number 3, the 3 main options in court. And number 4 will be the do's and don'ts for an initial hearing. Number 1, let's review what an initial hearing is and how you find out if you have one. So an initial hearing is the first date in your court case. A further initial hearing is the first date in your case if your initial hearing was what we call continued or rescheduled. These hearings give a chance for the judge to learn what's going on in the case and how to set the case on track for how it will proceed. So, how do you find out when your hearing will be? Well, you should have received notice about when your hearing will take place. Currently, initial and further hearings can be attended by phone, online, or by attending in person. The notice that you received could have been sent to you in the mail and posted on your front door. Or it could have been handed to you personally or to someone who lives in your house. If you did not receive a notice in one of these 2 ways, give the Landlord-Tenant Legal Assistance Network a call. The phone number is in the caption. You can find out or double-check information about your case, including the time of your hearing, by checking the court docket. You can find the court docket at this link. Once you click on the link, the website should look something like this. In the search bar, to find your case, you can either type your last name, first name, or your case number. If you enter the case number, you must enter it without spaces or with hyphens. If you use spaces, your case won't come up. Then complete the I am not a robot task, click submit. Now you should see your case. If you don't see your case or you would like assistance checking your docket, you can also call the clerk's office at the number in the caption below. Okay, number 2, what happens at an initial hearing? Okay, so now that you know when your initial hearing is, let's talk about how to prepare for it. First things first, it is extremely important that you show up to your initial hearing. You can do that in person or online. Either way, you should arrive at least 10 minutes early. Now, the court process can be pretty confusing, especially if it's your first time. So let's talk through what will happen. The time that your case is scheduled for is not necessarily the time that your case will be called. Generally, the court schedules the cases by the hour. So if your case is scheduled for, say, 10 a.m., you're not the only one. There will be multiple cases scheduled for 10 a.m. And what that really means is that multiple hearings are scheduled to take place in the hour between 10 a.m. and 11 a.m. At the top of the hour, 10 o'clock, the judge will begin to call the cases scheduled for that time block. Now, sometimes the court runs behind, and there may still be matters from the earlier time block being called even when you log on. But the judge will not discuss your case until you hear the court clerk call your name and your case number. If you have not heard your name and your case number being called, do not log out of the hearing. Even if you're in the courtroom at the beginning of the hour, unless the judge has called your name and case number, you may be marked as absent from your hearing. This is a commonly made mistake because some individuals will log on at 10 a.m., hear another case being called, and log off because they think they missed their hearing and they don't realize it hasn't happened yet. Don't let that be you. Now, when preparing for your hearing, it's important to leave at least an hour of time free. from the time your case is scheduled for until around the end of the hour. Like I said, sometimes the court runs late and it could take even longer for your case to be called. While you're waiting for your case to be called, you should remain on mute if you're attending virtually, or sit in the audience if you're attending in person. If you're really unable to attend the time that your hearing is set for, call the Landlord-Tenant Legal Assistance Network. Now, once your case is called, what should you do? Well, even after your case is called, you can't immediately start talking about the details of your case. There's typically a specific procedure that the judge will follow, and they'll usually start by asking the opposing party to speak at different points throughout the hearing and ask you to speak at different points throughout the hearing. The first thing you will always be asked to do is consent to the magistrate. Now, this question can confuse people because they don't know what's being asked of them. So let's talk about it. Now, as long as you're okay with your hearing proceeding with a judge called a magistrate judge in this courtroom, you can say yes. If for any reason you would prefer your case to be called in another courtroom with another judge, you can say no. Now, if you say no, your case will be rescheduled for a different courtroom on a different day. Magistrate judges and other judges all apply the law in the exact same way, but there's a slightly different process for appealing their decisions if you disagree with them, and this is why they require your consent before they begin to oversee your hearing. Now, after you consent to the magistrate, we get to point number 3, your 3 main options in court. So, number 1, you can request a continuance. A continuance is the court's term for postponing your hearing. When in doubt, requesting a continuance is a good option. A continuance can be helpful if you're not sure if you have legal defenses in your case and need more time to talk to a lawyer before moving forward. Now, to get a continuance, you should tell the judge, "I request a continuance with all rights reserved to seek legal counsel." If your further initial hearing, rather than an initial hearing, you can still ask for a continuance, but the judge may be less likely to grant it. So this might be a better strategy at an initial hearing rather than a further initial. Otherwise, all of the information in this video applies the same way to initial and further initial hearings. Number 2, you can request a bench trial. Now, a bench trial means that it's a trial before a judge, no jury. If you know you have legal defenses, meaning you know you have reasons why the landlord should lose this case, you can request a bench trial. Now, a quick note about legal defenses. Legal defenses are defenses that the law recognizes as why your landlord should not be able to succeed in getting a judgment to evict you. Common defenses are things like housing conditions issues. In non-payment of rent cases, they might be mistakes on your ledger, the record of your rent, or in a lease violation case, they might be false accusations against you. Note that needing more time to pay because you fell behind in rent is unfortunately not considered a legal defense. Now, if you'd like to request a bench trial, you can say, "I want to have a trial before a judge," and then explain your defenses. The judge will ask you a few questions, and it's important to answer the questions simply and honestly. Then, the court will likely set a date for mediation, a time to sit down with you and your landlord and a neutral third party and try and work out an agreement. And then after that, a trial. Your third option is to request a jury trial. We'll provide some basic information about this in today's video, but you can check out the Tenant's Guide to Trials flyer at the website linked in our caption for more information. We'll also release a video on this topic. Now, there's only an option for you to request a jury trial if you've filed what's called a jury demand and an answer before the hearing. If you filed those forms and you know you have legal defenses, you can request a jury trial. You should know that jury trials take much longer than bench trials, and they include more hearings that you must attend. But if you filled out the forms, say, "I have an answer and jury demand, and I would like a jury trial." If you haven't filed the forms yet, but you would like to and you're at your initial hearing, try requesting a continuance and asking the judge to give you time to file those forms. Once you've requested a jury trial, the court will set a mediation date and a trial date will be set later. It's important to note there is a $75 fee to request a jury trial, but frequently tenants can file a fee waiver form with the court, and that waiver form will allow the court to waive that $75 fee. Okay, point 4, the do's and don'ts of initial hearings. Number 1, don't miss your hearing. If there's an emergency, you can call the clerk's office to ask for something called an emergency continuance, which could postpone your case. The phone number is in the caption below. Otherwise, be at your hearing. Number 2, don't admit that you owe money. If you go to court and admit that you owe money, and you don't assert any legal defenses in your case, you could lose the chance for the court to listen to your side of the story and allow the judge to enter a judgment for your landlord right off the bat. Number 3, do tell the judge if you have a pending Emergency Rental Assistance Program or ERAP application. Some judges will choose to postpone your hearing while your ERAP application is being processed. This is not a guarantee, but it is important to tell the judge. Number 4, if your landlord requests a protective order, do ask for a bell hearing. If you have issues with your housing, like rodents, mold, broken heating, cooling, etc., or if you dispute the amount of rent that you owe. A protective order means that your landlord would be asking the judge to require you to pay your rent into the court registry instead of to them. A bell hearing is an opportunity for the judge to hear about the conditions issues in your apartment and set a lower amount of rent that you should pay into the court because of those conditions that in your apartment. And number 5, when in doubt, do ask for more time to speak to an attorney. Ask for a continuance. If you'd like a summary of this information in a written format, please pause this video and take a screenshot of this flyer, front and back. You can check out this flyer as well as all of our other flyers on topics like what to do if you miss a hearing, linked on the website in the caption. Good luck! And if you have questions or would like to see if you're eligible for free legal services, please call the Landlord-Tenant Legal Assistance Network at 202-780-2575. Thanks for watching.